Wait, how about it? Good evening. Welcome to our Wednesday business session. It is 7:40, 7:42. Sorry, I'm late. And that we're starting late. And we'll do the pledge and start the meeting. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay.
I'll take the roll. We have a special meeting first. Trustee Quezada,
Present.
trustee White,
Present.
trustee Fritchie,
Present.
deputy mayor Lopez,
Present.
Mayor Levin.
Present.
Is there anyone in the outside world who has a comment on the one resolution that's on
Something
tonight's
going
special
on?
meeting? Hearing nothing?
No, nothing.
Hold on.
Thank you.
Oh, okay.
Resolved that the Board of Trustees approves the stipulation of settlement with Village of Ossining employee 6948. And be it further resolved that the mayor and village manager are authorized to sign the aforementioned stipulation of settlement on behalf of the village. Do I have a motion?
So move. Second.
Any comments from the board?
All in favor?
Aye.
Thank you. Do I have a motion to adjourn the special session and to go into work session?
So move.
Second.
All in favor?
Aye.
Thank you.
Good evening, everyone.
I think should we do announcements first?
Oh, I'm sorry. I thought you said no one out.
No, they don't. So, I hope everybody comes out. We're gonna have a Memorial Day parade, getting everybody, put it in your calendar. Always a lot of fun, especially if the weather is, wonderful. Also, as I drove down here, I hope everyone's taken note of the, wonderful banners that are on Croton Avenue. It's our first sort of annual event of the like, and we have 62 banners up to honor folks in military, past and present. And we're very excited about it, and it's actually very lovely. I was talking to the assistant village manager earlier, and she was talking about how moving it is sometimes when you just stop and look. And I think it's true. Also, the flags are done beautifully. Dana White's dad's up there.
Today I went and search of him. I found him. It's a great location, actually, right across from my favorite pizza place and at the corner of Pleasantville Road and 133 Roosevelt Square.
The way they were done is chronologically by wars. We have somebody from the Civil War up to present day, in case you're looking for somebody, whether you're related to them or you just happen to know them. So, and I think it'll look lovely in the parade also, on the day of a parade. I think they'll be up till Veterans Day. Those, bless you, a lot of allergy season, huh? And then we're going to open up the website. It's not necessarily ours, but from the company that's doing this. And we are conduits to making it successful. DPW hung everything up. They'll take everything down. For those that requested, they will store them so that we have them for next year. And very, very fun, very exciting. I also was at NICOM. Is it only last week? It feels like longer than that, which is why I wasn't at the meeting last Wednesday with Maddie Sahaj. Learned a lot. We're going to talk about a few of the things over the next few weeks. One of them are new regulations from OSHA about fire departments and firehouses that I'm sure Trustee Fritchie will be educating us further. But we had separately a meeting today with some folks from the fire departments. So we just sort of talked to them as well about a couple of issues in their point of view so we can get opinions about it. So these are really exciting things. Basically, I also learned that here in Ossining, and I'm not patting ourselves on the back. I'm here to tell you that when you look at what's going on throughout the state of New York, especially in the smaller communities, but actually I think even in the cities, which are the size of Poughkeepsie, of Ossining, but up in Western New York and Northern New York, we are really doing a lot of things well and a lot of things right. So it's also nice to be able to see. We learned a few things, the placemaking actually. There were some ideas, although we've looked at some of those ideas, so we feel really good about where we are. We learned something about cannabis. It is not going as well as far as code enforcement. As I think some folks who are big proponents, many people on this board are big proponents of the cannabis legislation, but the state is really behind in enforcement and funding. It's in a whole bunch of other issues that have come up, predominantly in New York City, but also throughout the state of New York. So that was another learning that we had while we were up there. For some people, not surprising, but for me, it was just nice to sort of hear what other mayors had to say about that. And we also reviewed what the governor is doing as far as different pieces of legislation, which are publicly listed by government. So anybody wants to look at it, I didn't see anything that directly affects Ossining any differently than it affects the rest of the state. So I think we're in the same boat as everybody else, whether you like the boat or not, we're in the same boat. I think that's basically all the announcements, except for the fact that one of the mayors here in Westchester is actually been hospitalized. And I wish the mayor from Mount Vernon a healthy recovery. They're going through a lot of stuff right now. It's a tough gig sometimes when you get hospitalized when you're a mayor, because there are a lot of responsibilities, and they're sort of working through what to do with that. So I wish her well, and I think we can get started.
Good evening, everybody. Dale Brennan, our treasurer, was planning to be here tonight, but she had a family issue that she needed to attend to. So Maddie and I will be talking about capital projects and some ones that need cleaning up. There are 3 that need to be established. And those three are for the recent wins we've gotten through OPD for grants. So that's equipment for tactical team, critical infrastructure, and our fixed location license plate readers. And we'll also be setting up a capital project for the new Indian Brook water treatment plant so that we can allocate the village's ARPA funds of $2.5 million to that project. So with that, I'd like to turn it over to Maddie and just go through in a little bit more detail, and then we can answer any questions the board may have.
Thank you, Karen. Good evening, everybody. Again, so we are pinch hitting for our treasurer. Happy to answer questions as best we can. But Karen said most of it. So we are establishing 3 capital projects, or planning to at the next legislative meeting, I should say. All 3 are related to grants coming out of the police department. You heard a little bit about that. I think it was last week or maybe 2 weeks ago. I'm very excited about those. So those are relatively what do we got? Federal grant for $75,000 for equipment purchases for our tactical team, $50,000 for critical infrastructure grants to mitigate vulnerabilities of critical infrastructure, and then $150,000 towards fixed license plate readers, which will go at all entry and exit points to the village. So we're excited about those. Then the next one is actually capital project adjustment. So as we know, we've heard an awful lot about the Indian Brook water treatment plant, which is going to be beginning construction hopefully any day now. But the budget adjustment that the treasurer is asking the board to consider at this time is the board may recall, I believe it was in 2021, that the village and all other communities throughout the United States were allocated money under ARPA, which is the American Rescue Plan Act. The village was awarded a lump sum of $2.5 and some odd million. The board at that time made the decision to earmark that specifically for the Indian Brook water treatment plant. So now that we're getting ready to go, we're formally doing that, or again, requesting that the board do that by resolution, also on June 5th. Then finally, there is a series of much smaller capital projects that the work is done or nearly done that need to be adjusted and closed. The board has been provided with the treasurer's memo, so you can kind of follow along. One of them is to close out the parking study. You may remember from a couple of years ago to balance out the grant funding. I think we came in a couple dollars under. Most of these amounts are pretty negligible. You can see there's one that is 25 cents. Most of them aren't that small, but there's a laundry list of capital projects that we've actually had a little bit of overage, a little bit of under. So Dale is looking to balance all of those out so that we can close them and move forward. And again, the board has this memo. It's also embedded in the agenda for tonight's work session. If the board is aligned, we can put these on the June 5th legislative meeting, and Dale will be very happy.
Great. Anybody have questions about the laundry list? Anything specific before we vote in total? Or not vote, but recommend that it be put? Is that, oh, I'm seeing, everybody okay? Everybody okay?
So the question about the 25 cents.
Yeah, I knew you would. I knew you were gonna call that one out. Listen, we are very thorough, okay? So that's not a rounding error. We need to be very on the point.
Yeah. You rounded it up? Okay. I think we're good. We're not voting, we're just, I think there's a total agreement here for the next one.
Fantastic. Thank you.
May not be.
Sorry. You also received a fairly lengthy local law for review for this evening. Stuart's been working diligently on updates to Chapter 162, which is housing and property maintenance. This proposed law will help align our code with New York State's, and I will turn it over to Stuart.
Thank you, Karen. We're actually going to flip so that
Oh.
Valerie,
Oh.
Leave,
Valerie's thing first.
Oh, okay, I'm sorry.
No, I can, so,
but we like having Valerie stay here till all hours.
the discussion, with regard to Valerie relates to, a proposed law that was sent around to you for rental registry.
Mhm.
And also a discussion about, at an earlier board meeting, there was some discussion about potential local law relating to change of ownership. We'd like to deal with the rental registry first, and we can deal with the change of ownership next. The proposed local law for the rental registry, and my great thanks to the folks at Nelson Pope for doing this, and then my remembering how to format all this stuff at some point. But what this would do is establish a rental registry for 1 and 2 family rented or leased properties within the village. And just so you know, because Valerie and her folks were able to provide this to me this morning. Currently, or under the Westchester GIS, there are at this time 2,675 parcels that are coded 210 for assessment purposes, which means single family. There are 768 parcels coded 220, which is 2 family. As to the 1 family, we can't tell you if they're leased, rented, or whatever, but 2 family, it's pretty good guess that at least 1 of those units would be rented. What this local law would do is that those particular locations would have to enter into the registry so that they can then in fact be subject to potential inspections by the building department to check out what these circumstances are. Currently, it's really 3 bedrooms or 3 dwelling units and up. This would basically take those other buildings there to do the registering. The landlords would be required to register. There are provisions in here for obtaining a warrant for what the warrant application must say. It's very specific that if there is a tenant in possession, you can't just basically go in, you have to provide prior notification. If it's the owner and there is no tenant and the owner simply says you're not coming in, you don't have to give the owner any more notification. You can just go to the court and get the warrant. There is also a provision in here whereby if you have an owner who is not a resident of Westchester County, they must appoint an agent who is in Westchester County. And that agent would be someone who would be designated to essentially accept all legal papers, all appearance tickets, all OTRs, and basically be the contact within the village to do that. The inspection here is specifically an inspection to see that it is conforming with the building code, which is the other part of 162 that we'll be talking about in a little bit. There are provisions in here as to how to get the rental registry certificate. I believe we have it. It's a 2-year certificate, and that how it could be denied. Basically, one other thing that's important in here is that for many of these properties that are owned by LLCs, LLPs, PLLCs, partnerships, whatever, they are going to be required to identify all the members. And initially, they'll be required also to provide either a management agreement or a partnership agreement so that we can see who those particular folks are. And so it's try to avoid that they're essentially hiding behind something. One other point that's in here is that when the owner provides an address, a PO box will not be accepted. It has to be an actual street address. And that information has to be provided to the tenant. The rental registry certificate will have to be posted in a common area of the building. If there is no common area of the building, it must be posted in each unit of the building so that the tenant is made aware of exactly who the person is that they can get in contact with. If in the event the owner sells the building, the new owner has to basically can get the certificate transferred, but they have to apply to do that. It's not an automatic transfer. And so they have to go through that particular process to do that. And there is a provision in here on how do you renew the certificates and how do you get new certificates. Finally, we have the board will have to at some point determine what the fee should be for that. And we have a whole section dealing with penalties. One sort of little bit of difference that we put into with the penalties here is that in addition to the penalties that could be imposed, be it a fine or potentially imprisonment, the court could actually impose a penalty based upon loss of profit. Essentially, how much money this person was making illegally by operating that particular building. And that is actually in at least one other jurisdiction in the state of New York that has that particular language. What the courts might do with that in terms of awarding it, it's not clear, but it does provide another basis for a finding. You may have property owners who think, I'd rather not lose the possibility of how much money I've been earning, because they would have to actually give that information to the court, and the court could, if it wanted to, do that. One final thing that I did not mention, but it's important. If the building is not in compliance and there are tenants there, the landlord is not supposed to collect rent during that period of time. What would happen is the landlord is allowed to collect what's called the equitable value during that period of time, but he can't actually collect rent. And secondly, now that because I'd forgotten earlier, there is also a provision in here that brokers and agents cannot knowingly show a unit where in fact they are aware that that unit is not properly registered. Building department will have all this information, so they can easily find that out. But so liability could be imposed upon a broker or an agent, or if they are in fact showing a particular location, knowing that the location is in fact not properly certified. So that's that. As I said, we went into what the penalty. There are penalties in terms of what the numbers are. There's also a civil penalty that can be assessed. Difference between a fine and a civil penalty. The fine goes through the justice court. The civil penalty does as well, but to recover the civil penalty would require a separate legal action brought by the village, sort of a judgment that would be rendered against the property owner for the particular amount that is that is there. I think that's it. We wanted to put in very strong warrant language in here because we thought it's very important that the owner know that if they say no, we're not going to come in with gangbusters and just come in, but that we do have the right to then go to court to either compel them to let us in or to get a warrant. There's also a provision in here because it is something that is seen in most municipalities that have this warrant language, that if the police are included in the warrant to go in, they cannot go into locations which are basically sort of off limits to the property inspector. They basically, this cannot become a fishing expedition for the police to come in. Generally, it's anticipated that most of these warrants will be carried out by code enforcement personnel. They have the authority to do it. And the most recent warrants that we've gotten from the Justice Court are in fact in the name of code enforcement personnel. We've had police assist us on some of them, but generally it's code enforcement personnel. It's the code enforcement personnel who prepare the order, prepare the warrants, and get the warrants, in fact, present them in court. So that's in a nutshell, what we have here. One last thing. If you have an existing rental and you've submitted an application, you can get a provisional certificate allowing you of compliance with the rental registry. That's good for 180 days. So basically, it is presumed that within that 180 days, you'll allow for the inspection, they'll come in, you'll make whatever repairs have to be made, if any have to be made. And then that provisional will be turned into full. And again, as I said, it's a 2-year certificate, which can then be renewed by the property owner.
Right, and I just want to note that like the overall approach is very similar to other communities that, like, for example, have accessory dwelling units that require like re-inspections every so many years. So it's not, you know, I mean, while we're calling this a rental registry, it's very similar process that takes place in other communities for various other types of like special permit uses or accessory dwelling units.
Okay. Thank you. Do we want to start on this side for questions? Sir? You have none, and your opinion is a green light, a red light on this? We're being asked for next week to be put, right?
It would be to call for a public hearing.
Sorry, to call for public hearing. Okay. Manny?
Thank you. I have a few questions, because I believe in the past, we have gone through this exercise before.
Yes.
And one of the things that we talked about last time, or last few times, many years ago, there was exceptions. Who can be exempt from this kind of situation or this form? At that time, it was if it was owner occupied. And my recollection was that I believe the last conversation that we had, I don't think that changed or deviate of what the law should state. So I didn't see, unless I'm missing the exceptions in here, I don't see exceptions
So
in
we
here.
have in here for 1 and 2 family buildings or structures occupied exclusively for resident purposes, which are intended or which are rented, leased, or let or hired out to be occupied for at least 30 days. So if it's an owner occupied single family home, they do not have to,
I
right?
think it has to be more
We
specific
can,
than
we can
that.
make it. specific.
Yeah.
So, because we've specifically referred to buildings as opposed to individual rental units, but we can make it.
Yeah, because I think that was one of the things that I don't know, I can't remember if we had that last time, but I remember that was one of the things that we, as far as I remember, and the board can correct me, I don't think any of us deviated from the exception portion of that, because we felt that it was strongly, anyway.
If I may, I just want to be clear then, exactly then what you want. Do you want to exempt all owner occupied?
That's what we talked about last time, yeah.
Because then what you're doing is any owner occupied building, even if it's a 2-family, is not subject to inspection.
Correct, that's what we said last time.
I think you were doing with that with more than 2. That was originally, because with the 1 and 2, the idea was, Maddie, go ahead.
I'm sorry, my understanding was a little bit different, but I thought I was saying the same thing as you, and maybe I am. So if you're a single family home and you're renting out the whole single family home, this doesn't cover you. If you own a 2-family home and you live on the left, but you have a tenant on the right can be inspected, the left cannot.
If you have a single family home and you're renting it out, that is subject to
That's
the
the-
rental.
yeah,
registry.
that's subject
Yes,
to rental,
yes,
yeah.
So I'm backwards. So forget the first part of what I said. If you were a 2-family home and you're the owner and you live on the left and you have a tenant on the right, the unit on the left will not be part of this registry, but the unit on the right will. That was my recollection of our last conversation, and maybe that's.
It could be, but you know, even a single family home, if it's owner occupied, that was not gonna be part of this. Because that was an
Well,
exception.
a single family, if owner occupied, wouldn't be rented. It's a single
It
family.
doesn't matter, I mean, but.
No, but
you
it's
know,
a single family, so it wouldn't be part of this.
You can, you know, it's subjective, I guess, because you can have, you can be a single person and you can have roommates, so which is.
That's
It's still renting part.
The real issue is not having the entire building or the entire structure being rented out, and
Okay.
you're not there.
So I'm gonna have to hold on to that one, because I will have to go back to the last meetings that we had then, because I want to make sure I'm supporting the right portion of this, so I'm
So, I
gonna
mean, we can-
apologize for
right,
that.
we can talk about this a little bit more, because I mean, that's a simple, I mean, I'm gonna say it is simple in terms of tweaking a definition. So I think just
Yeah.
a final decision on that
Sure.
is something that needs to
Yeah.
do.
The other portion, and I don't remember, I believe me, I don't remember having that time frame of, of how often was gonna be the register. That I don't remember, but definitely was not it could have been 2 years, I just don't remember that portion.
And so that's something else we are suggesting 2 years, if you wanted to, align it with like the final inspection, you could do 3 years, right? And then so that every 3 years, they would fall within the same inspection time period as your 3,000 multiplies
Sorry.
as an option.
Yeah, I don't remember, I'm not sure, I'm either or. I think the biggest concern that I have is, and probably Maddie, you can help me with this, so forget about this for 1 second, okay? We have our inspections every 3 years. How backed up are we right now on those inspections? Are we up there right now? Are we like up to speed with what we have?
Right, so my understanding, and I think Karen spoke to the building inspector about this more recently than I. My understanding is that for the every 3 years, which is 3 units or more, fire inspections,
Correct.
we have about 100 that we need to complete in the remainder of this calendar year. So we're in mid-May, we have about 6.5 months to do 100, should be eminently doable.
So a year, how many inspections, fire inspections do you guys? do?
That I don't know off the top of my head, but we could get it.
Things that, one of the things that we've been talking about is now that we have a deeper bench of staff, is even the way we're scheduling these inspections. So whether they're fire inspections or rental registry, it appears to me that we have the capacity to do those. And that would be the argument for every 3 years, just to, or we could try 3, and if we can do them more, whatever. I'm kind of agnostic on that. But we have an opportunity to do this in a bit more of a strategic way, and it's actually something Maddie and I were going to be talking about with the staff this week, because, you have periods of time where the building department is very, very, very busy, and that's obviously in the warmer months. And then you have periods of time where they're always busy, but a little less busy, certainly in the colder months. So like focusing more the proactive inspections at a time of year, and then making sure that we're going through and that we're looking at through the lens of how many inspections, how that gets divided, who's doing what, and have those metrics. So that way we'd be able to keep those numbers fresh and be able to report to the board exactly where we are in any given day.
Okay, that sort of doesn't really quite answer the question that I had, but okay. So in the building department, who's qualified to do fire inspections?
Code enforcement officers and up.
Okay, so pretty much everybody in the staff in there. So I'm assuming that the concept is, if the board is willing to pass this law, some point in time, everybody starting from code enforcement, assistant building inspectors, do also qualify to do the inspections for the rental units, correct?
I believe that's the intention, yes.
Okay. My recollection as well, and I remember this, the last time when we had a proposal for this, it was the main reason why this law did not pass is because of capacity on the building department. Based on the numbers that Stuart just brought up in regards to single families and 2 families, plus the amount of multifamilies, I'm gonna call it, in fire inspections. I still feel that this is going to be a very difficult situation to put that back into the building department itself. And my concern is, even though I agree with a lot of the stuff in here, my concern is that, it's not going to be enough. The personnel is not going to be enough. I mean, I have spoken to people in Monquisco, which is one of the municipalities that does this. They don't do register. They don't do inspections as often as they would. And they have a lot. And other municipalities that I have seen is just this, they always struggle with this. So for me to put a law in place that we cannot be able to enforce the way we are thinking that we're going to be enforcing, and then at some point in time, in a year or 2 years, village managers and just staff in general is going to come back to this board and say, well, we need more people to get to the level that we are. That will be the biggest concern that I have. So I still have to do a little bit more of, like I said, I'm gonna go back to some of the meetings that we had in here just to refresh my memory in there. In concept, I'm okay with this. I just think that there's a couple more stuff that I would like to add to this, but I'm gonna hold on to this. If the rest of the board is okay with this, then I'm sure this is gonna move forward. But I have concerns.
Dana?
I'm not sure I was here when you first discussed this. Was I? So that's why I'm gonna sound ignorant.
The last time that we discussed this, I believe, was at the sort of catch-all building planning work session back on January 31st. So it's
Oh,
been
okay.
quite a while. Yes.
Oh,
that
it
here.
was, okay.
And it may have come up.
I was here.
It was part of a broader conversation, so I don't think we discussed it in as robust a detail.
They were asked to come back with a more
Mhm.
detailed plan. That's
what are
what we're
the-
doing tonight.
Okay, what are the benefits of a rental registry? For us?
It will allow the building department to make sure that the locations that are rented are up to code.
Mm.
The simple fact of the matter is that unless we're aware of a complaint, we can then get a warrant to get in, we can't get in. The registry does two things. One, it gives us a list of what those particular properties are. And we know where they are and we know, who's being rented to. Also, one of the problems that we have is we have many, many absentee property owners. I mean, more than you can look at. This would give us, as would the 162 revision coming later, the ability to get the names of who all the members are, who all the people are, have them designate an agent. We have people who own buildings, they live in California, they live all around, and we have no way to get, but if they have to have someone here to make them responsible, but from the building department's end, it gives us the ability, if necessary. We go in, we can inspect. If it's fine, it's great. They get the certificate, they go on, they're fine. If it's not, we then can get, see whatever the potential violations are. And if they will not let us in, we'll go to court, we'll ask for a warrant, and the argument to the court is we're trying to just make sure it's in compliance, okay? We're only, and we make it very clear to the court, we're only doing, be it a property maintenance or a fire inspection. That's all we're doing. So we're not going to look for things which might otherwise be violations. We're not just writing things up. We've had this discussion with the court on a number of occasions, and it's been very clear. The court understands that's the reason we're going in to do that. But it's essentially to make these properties safe, because currently 1 and 2 families are not subject to a triennial inspection, which is what you do get with 3 family and up. So it sort of helps to fill what is a gap. And again, we're providing due process. As I said, if they don't want to let us in, they don't have to. We can go to court. But if they don't let us in, then they're not going to get their certificate. They don't get their certificate. By law, if it's adopted, they couldn't collect rent because they would not be allowed to if they're not in compliance.
Hmm.
And so that's another aspect of it. So
I mean, it sounds like a huge enforcement issue. I mean, we have a lot of rental properties. These are houses you're talking about, not necessarily buildings.
No, these would only be residential. For
Right.
example, if you have a commercial downstairs and 2 apartments upstairs, that's considered a commercial building, so it's part of the 3-year inspection
Oh.
process. These are only residential.
It would make it easier to find the owners too, if there was a
Well, that's one of the
crisis.
problems.
I heard that, that there was an issue
Mhm.
recently with a problem with a property and nobody knew who owned it, but there were people living there renting, but the owner was like somewhere overseas.
One of the issues,
You're on, I think. Well, maybe not, sorry.
I don't know. When the village started enforcing the fire inspections, it did make things more difficult for the larger multifamily properties. The challenge that we have now is, the housing crisis is significant and people are looking for ways to rent and people are looking for ways to live in communities they want to live in, whatever the issues are, this is another tool. So while it is a capacity issue, and I think that's a really important concern, we don't want to do things that we can't enforce. On the other hand, we know one of the biggest complaints we get right now is in the smaller rental units where we're not able to check because we can't get in and people will complain, but I know I see, 15 different people going in here. There's 10 cars parked outside, all of these things. It would give us the advantage to be able to also do those inspections. So we're really caught in an issue of like, where do we want to concentrate our resources? What's our biggest issues within the village? And if we agree that this is something that keeps coming up as an issue and a quality of life issue, making people sure people are living in safe conditions, making sure that we have adequate parking for all residents who live in a particular area, there are things that we need to be able to do that we can't do currently.
And so people could potentially be unhoused if they are found to be living in an apartment that is not legal. Right.
That's the idea of the provisional certificate. So if you have a building now and the owner would have 180 days to get a full certificate, they get a provisional for 6 months. Theoretically, could it result in people? We are not going to be evicting people. If we don't, we don't evict people. I will say that if we were to go into a building and find significant life safety issues that were threatening, we will placard the building and we will try to make arrangements for those folks. But that's at the very end of the spectrum. What we generally try to do is, basically get the places up to compliance. The big concern that we have in a lot of places is that someone will have done electrical work with no permit. We have no certification. They'll do plumbing with no permit, no certification. We as a village and Joe as a building inspector, they have no way to know if that in fact is done appropriately. And so we don't want folks in a particular location like that. But that's, as I said, that's at the far end of the spectrum. Generally, it's just to go in. It's not to, if you want to call it unhouse people, but it is to basically make sure that the locations are safe.
Well, one of the things that, at that meeting, Joe mentioned was that, when they first started with the fire inspections for the multifamily buildings, that at first there were a lot of violations, right? But now that system is in place, they're finding that basically there's a lot less violations, right? Because property owners now know that this is what is expected. So, there would potentially be a little bit of that at the very beginning, but once it's known that these rental registries are required and those inspections are required, you would probably get more compliance.
Evicting people is rare. And again, it's only when literally they are risking their lives staying in a place that's not safe. So to Valerie's point, one of the things we found is that there's an element of exploitation that's happening too, where people are renting. People may not realize that they're entitled to certain things. They're not necessarily paying inexpensive amounts to live in these conditions, as we've found out. So there is opportunity, and what we find is usually with that pressure, the landlord will comply with whatever orders to remedy there are, whatever there needs to be done to make the place safe, because the bigger investment is that being able to rent. So again, it's always a challenge because we know that it's a challenging issue. The more tools that we have, the more effective we can be. I believe that this is something that we can manage based on what I'm hearing about the current fire inspections from the building inspector, and how we sort of schedule those a little bit more proactively. And now that, again, we're working with more staff, we've essentially doubled the amount of staff that we've had to do this over the last 2 years. So again, those are the pros of being able to do that.
Dana, any more questions?
No, that's fine.
All right. Great. So I like most of it. I have a couple of questions. I too we've done 3 years, but we're doing this in 2 years. I'm agnostic to that too, whether we go to 3 or 2. 2 sounds fine, but I don't know. I mean, you guys sort of put a stake in the ground. I could go either way on that. I like the certification idea. I think it will actually, what I like about this and the benefit to the community, I was thinking about what Dana was asking, is that we have always put the onus on the renters. People come in from wherever, they finally find a place for their family. They got to jump in and make, and put money down and whatever they have to do. And then they find out they're living in an illegal whatever, or, the way the boiler is set up is not supposed to be that way. And now they're fighting for something that doesn't have anything to do with them. I actually like putting the onus on the landlord. And I am happy to answer phone calls from people who own houses who have moved to Florida and to, Ohio and Vegas and all these other places, leaving these houses because they make so much money. So much money. When I was at Nikon, people said that the fines were meaningless because people, even north of here, out of Westchester, are getting $1,500, $2,000 for studios or 1 bedrooms. And like, it wouldn't matter how much you fine them because over 12 months, and many of them collected in cash. And so the registries have helped to sort of bring light on all of that because the landlords have turned their houses into businesses. Good for them, but they don't function like a business. Businesses have to follow rules. They have to have certain things in place, like appropriate bathrooms, for example, et cetera, et cetera. And you know that I've always said, this is not about the bad characters. It's about the good characters. It is unfair for people who follow the rules and take their house and rent it out appropriately, who should get a certificate and should get all of their stuff in gear, to be next door to somebody who somehow has 10 cars every night in front of a neighborhood where none of the neighbors can then have parking. Because there's so many people living next door in a 1 or 2 family house, and somehow there are 10 cars every night. So the bad characters profit, the good characters sort of sit there going, man, this is like getting to be a tough gig. So I actually think the onus should be on landlords. The thing I would add on there is you're doing inspections for safety. I would have added parking in there. As I've said to people who complain to me about, well, there's not enough street parking, and I was told I could park on the street. Yeah, but you've got a 1-family house that somehow has 4 units in it. Everybody has 2 cars, that's 8 cars. On a linear street that probably holds 20. So talk to the guy that's collecting $2,000 a month from you and tell him to give you a parking spot somewhere. I think the onus has to be. And what the attorney has said, which has been apparent for the past decade, that people are hiding behind LLCs and LLPs and they go to courts and we can't really do very much and they're not even around. They don't show up to the court, they're not around. Our staff has to find them, who knows where they live, they've got it in this person's name and that corporate. I think, again, the onus should be on the landlord. They are the ones that profit, seriously, and they should be the ones that are held responsible for the safety of people that they're renting to, and that the plumbing works and whatever else needs to be done. And so I sort of like this shift. And there was, I don't know if you sat in any of the rooms, but there was a lot of conversation about registries and how different folks do it. And they all believe they're not charging enough of a fine because the fines, it's become so profitable because there is a housing shortage. So it's become profitable. On the other hand, if you own a house and you move on, you were transferred for 2 years, somewhere, and you don't want to sell the house because you want to come back to Austining, you shouldn't have to sell your house. You should be able to rent out your house easily and comfortably for a couple of years or whatever you want, and make sure that there's somebody you can reach. We do have a problem reaching bad characters when we need them. And so for me, this also alleviates that big issue. So it hits a lot of issues. What I don't get is the punishment part, is the punitive part. Like, I just don't register in my house. I don't tell anybody I'm renting my house. How would we even know that you're renting house on 1 Elm Street if you didn't tell us? Like, how would we know that? So I don't know how we're accounting for people who simply just won't register.
Mayor, to be honest, that happens in every single walk of life. The bottom line is there will be people who will simply absolutely ignore this.
Hmm.
To the extent that we can become aware of it, and sometimes we do, because sometimes we see ads for places that are being rented. I can tell you that I know places that are going for sale or being rented, because I get FOIL requests for multiple,
Right.
for multiple properties. So I have a fairly good idea of what's going on in terms of that. But will there be bad actors who will simply never register?
Right. So what is the punitive action on that?
Well, the penalty is that if they do not register, the fine here is excessive. I mean, the fine here could be starting at not less than $3,500. That's the fine. Or the loss of profit, which is potentially 2 times the profit that the person is making off the building. You know, with some of these all cash places, that could be an awful lot of money that person might lose out on.
Yes, you know what they're actually charging.
Yeah, that's correct.
So if I may add, if you could look into this, I would actually index and not go with what they're actually charging, but what the going rate for like a 3-bedroom house is. So it's either that or what they prove they're billing. I think you need to have an index because, you know, people are going to tell you they're charging $500 for, you know, an 1,800 square foot house. And since they get cash, which is perfectly legal, you know, you're not going to know. So you could find some sort of an index that at least lets them know that, like, if you could show that you get, and that's what you're getting, cool. But, you know, otherwise, here's what the judge works with, which is an index. None of this is supposed to be punishing people. The problem is we have people who own houses. We don't know who they are. They don't take care of things. We spend days and months trying to find them. Then they don't show up. Then they're out of the country. Then they're, you know, 101 things. So I like the idea that there's somebody here in Westchester whose name is attached. Because again, you've turned your place into a business. I have no problem with you turning your house and making $2,000 a month on it or whatever you make on it. Good for you, but you can't just get the money and not also put an investment into the conditions and the safety issues and the municipality who has to pick up all the other stuff that's happening there. So I think it's really important, especially if there's a fire or there's other things that are going on there. So I like a lot of what you have. As I said, I don't know about the, you know, the other piece of what happens, the punitive side of, you know, what happens when you don't do what you're supposed to. So I can't tell from what I read. I also, I don't know what the remedy is. So somebody does something, is it the same as it's always been? They just go and remedy the situation and it's all cool?
If they're doing if the building department does an inspection and they find a violation,
Hmm.
they would issue an order to remedy. And they would have 30 days to remedy that. If it doesn't get remedied, it turns into an appearance ticket. That's also the benefit of the provisional certificate, which basically will allow them to continue to operate for 180 days. Presumably within 180 days, they will have the violations cleared up and they will take care of it. The other, to get back to what you're asking, the sort of impact is that if they don't have a building that is certified, they're not supposed to collect rent. Now, I realize again.
But they will.
The issue,
Right.
right, but if they do, and we find out that they are, they again face penalty provisions of the code.
Okay. I mean, none of this is perfect, but I think it's closer than what we have. And if you're in a 2-family house and find out that it's been turned into a 3 or 4, what happens in that case? They don't get a certificate, I assume, or they could be told you turn into 4, but it should be a 2, so turn it into a 2. I mean, I don't know how this works.
Well, I would say it's gonna be the same as if, you know, the building department gets a call and they find out that there's illegal apartments taking place. I think you're gonna find that, you know, somebody's not gonna set up an inspection for the building department to enter their home if they know that they have like a number.
Valerie, can you put your microphone on, please?
Oh, it is on.
Oh, okay. Do you mind leaning towards it? I'm
How about
sorry.
this? Better?
Much better. Thank you so much.
So if somebody if the building department's asking to have the inspection and they know they have illegal apartments, my guess is they're probably not going to easily have the building department come in and enter that.
But then you're going to get a warrant to go in.
Right.
Okay.
Right,
And
so,
the other point is if it's, let's say, a 2-family and they've converted it to a 3 or a 4, they're then almost certainly in violation of the zoning code,
Right.
which has significant violations, because the only way they would then be allowed to operate legally would be to get a use variance, which it would be very difficult to get.
Okay.
So, yes.
All right, so this answers a decade worth of requests for, we also don't have data. We all sit around because we live here and we guess that we know on our block, there are 2 houses that have been turned into whatever. And they could be perfectly fine inside, safe and fine and all that. There's nothing to say that they're not. But we have like no information. So we do know that a lot of people have kept their houses. In the old days, people bought, sold at a profit and moved. But now it's more profitable to keep your house and turn it into rental units. And as long as that exists, we're going to have good characters, probably 80%, 85%, and bad characters, probably 15% to 20. That's usually what we work with. And I think that's what we're going to find out. It's the same thing here. And there's a 30-day provision. So it's rental more than 30 days, correct?
That's
Is that
correct.
right? Okay. So that I think also works to the other conversation we had. Because I don't know if you picked up on it when she was saying that, but I did. I would love to work parking into this if they have, although 2-family, they probably are okay with the parking. It's really when it gets beyond that, that the parking starts being a challenge as to what they should supply. So maybe I'll leave that alone. I don't know. I feel pretty strongly that that's causing one of the major problems in our residential areas. Okay. Is there anything else that we have left off? 1 or 2 families, we got that. Okay. I mean, I don't remember all the conversations, but I think you all went back and came back with a more detailed plan based on what others are doing, what we asked for.
That's correct. I think the only.
It looks like
decision-
that.
I think the only decision that we need to finalize is the owner occupied, whether that's going to also apply to 2 families. If an owner is living in one of the units and renting out the other.
Well, is that what your point was, or is
Yeah.
it's, oh, okay.
Correct. And again, I'm gonna go back myself because I believe that was something along those lines. Hey, Maddie, you could be 100% correct. It's a 50-50, I guess. My other, something that it was brought up, and I guess I would like to, you don't have to answer that question, but a couple of years ago, we actually did some additional enforcement in regards to, and I don't think we included this satellite TV, satellites into this, but I know we talked about satellites, we talked about mailboxes, we talked about
Oh, you mean
meters.
it's not like dishes?
Exactly.
Yeah.
Yeah, so we passed that law, or we passed something along those lines to help our code enforcement to go into properties that we have suspicion that they're running multifamilies in areas that were not multifamilies allow, or whatever the case may be. And we even talked about with the new programs or the new software that we have about water, the water consumption, and all this other stuff. Do we have an update, a data on what has happened since we actually established that law till now, and how we have enforced those areas at all?
I can only tell you this, that when I review the orders to remedy, it is often cited in the fact section of the order to remedy that, for example, 3 mailboxes are observed, or 3 meters are observed, or 4 meters are observed, because that at least, again, the way the law was written, it's a presumption, but it's not enough. It can allow us, if we think it's necessary, to get a warrant, but generally, if we're writing the order to remedy, we've got a violation, but I've often seen that is in the facts section where the code enforcement officer, assistant building inspector observes a couple of different mailboxes or things like that. We have photographs. We use it as part of our evidence in terms of doing that. I can't recall if we've specifically used that section as a basis to obtain a warrant. And we're trying to get away, Trustee Quezada, from using the water consumption, because that gets a little waffly at times, because, if someone has a leaking toilet and all of a sudden they're using a lot of water, that's not necessarily a basis to get into the property. But we did add to the code certain things that if it's supposed to be a two-family and it's got 3 mailboxes, you can probably presume it's really a 3-family. And so we can do, and so we have cited that. The other thing that we actually find that's actually even more helpful is a lot of the records that we get from the assessor, because sometimes the assessor actually lists it as a 3, even though it's legally a 2, because they may see a 3rd air conditioner or a 3rd unit. That then allows us to write a letter saying we want a fire inspection. And they'll say, no, it's a 2. Well, no, you're assessed at a 3. And it's kind of funny because we would say, well, if you were only a 2, your taxes would be this. And if you were a 3, it would be that. So you have a back and forth. But so a lot of times work from the information from the assessor's office, even if not consistent with what the building department has, provides us with another basis for actually entering into a building.
So I just want to add that we both were here hearing his question, and I heard it totally differently than you did, because you actually answered his question, but it's not actually what I thought he was asking. So now I'll ask it. When we pass codes and laws, we would like feedback on how they're being used and what the data is, so that we don't just pass laws, because now we're being asked to, a major law that's gonna like change things and there's gonna be blowback. So we pass those things specifically to solve a problem. And when asked, so how many of those are actually cited and all that, there's a lot of blank stares. And to your point, you couldn't tell me if it was 50 or 5, but you know that it's the case. So this might be either an intern project or something. But I think in fairness, when we pass, is that part of
Yeah.
what you were at? Okay, so we just,
100%.
you actually answered his question, but I just heard the question
No,
differently.
no, actually,
So
sorry, I sort of, you did answer, but I was actually.
You were asking more of
to
what,
what yours,
right,
yeah.
it's just from, it's like almost a personal thing. It's like, we sit here, we get asked, we are here to solve problems, you guys go, you do a lot of work. So a year from now, you are gonna be asked, so how many of these, this law, and does it change what we do? Probably not. If we talk about being data-based and really being able to say to the public, once we instituted that, we had 55 out of 70 that were stopped from doing what they're doing because we're able to go in, because we're able to get warrants. So I think this will be informationally helpful, that the building department actually give us back some actual data based on laws that we pass. We're not asking a month later, but certainly a year later, or like just to do a year in review. Based on this, we were able to X, Y, and Z. And I think we will learn that there are things that we passed that didn't do a damn thing, or wasn't even used. And so, when you sit here and you pass rules, I think you want to just know, hey, this is how it helped. Or it led to something else. Frankly, this registry is might eliminate some of this other stuff, but let's know that. And I think that would be very helpful, just
think
as
that-
general
I
knowledge.
think that Maddie, Valerie, Joe, and I can sit down and develop something that can give you an idea. In other words, we know the sections of the code that are cited in every violation. We know that. So we can certainly use that to come back to you and say, well, we get a lot of these, and
Right.
we don't get a lot of those.
Right.
We see this all the time. Lacking a building permit is 75% of the violations written is not having a building permit.
Okay.
I can just.
Oh, I totally get it, but
we
you
can
understand what
certainly-
we're
we can
saying.
Certainly
Yeah.
do that. Yeah.
And again, at some point, I would use a 1-year rule. When we pass something, 1 year later, the board should it'll also be helpful for new board members, for new judges, for new whatever, like, okay, so what did this actually do would be very helpful. We're not passing laws to punish people. We're passing laws so that people who live in a community have a better quality of life, because their quality of life isn't just what they do, it's what their neighbors do. And I always think about, what are the neighbors doing? And really make sure that the people who follow laws come home and have a decent life. And those that don't, we have to help sort of figure out how to stop them from making others suffer. Because that's really, if we lived in the country and everybody had 5 acres, we wouldn't be having these discussions.
We'll be in the town of Austin.
Oh, the town. Oh, well, we pay taxes for village and town, so. Well, you're gonna say something and we can move on?
Yeah, just briefly, I agree that holding the landlords responsible, because I hate to see people who rent totally innocently believe everything is fine and they're gonna be fine, and then it's not fine and they suffer, and that's not right. And So I think anything that kind of helps to try and course correct some of that so that the people who need a place to live can be sure they're actually going to be in a legal place to live and won't all of a sudden find that they're not and that they can't stay there anymore.
Right.
And that is just kind of heartbreaking,
Yeah.
and so if we can help to stop some of that, it would be great,
I do think, by the way, that most of our realtors are okay. I've only seen one realtor who says things like, oh, don't worry, you can rent this bottom basement because it has a walkout, which was false. And then the person was smart enough to say, then I won't do it, and didn't go for that. Although she called me up and she said, look, it makes this very different economics. When the realtor showed it to me, I included a certain rent. Now I have to borrow from a relative and then pay them back over time. And I felt bad for her because she didn't know. And the realtor was sort of dealt with, but what they good? They don't lose their license. They don't. The accountability is very low, frankly. That said, a lot of the stuff is now done online, and I think it just but I appreciate that you put the realtors and let them know that, hey, what's allowed, and you're supposed to be ethical in the way you deal. So I think that's good. One day we'll figure out how to deal with the online sales that have been going on and rentals. But that's let's get this done first. Let's do one thing at a time or 10 things at a time before we go to the 11th. So I think most people are okay with most of what you have. I think not 100, you have a couple of things maybe, but we're certainly closer than we were in the past.
I think based upon what we've heard from the board, we could come back on June the 5th during continuing business with the tweaks here and then with a vote for a public hearing sometime. in
Right,
June.
because this was actually a request from the board whether we can go to public hearing
Right.
and all that, not actually, this is the way the law is going to be. So it gives us a little tiny bit of wiggle room, tiny, because, not everybody shows up to these meetings. Okay,
The
what do you got
other-
next?
The other thing that the board had discussed back in January and had discussed at least since 2014, my records go back, is the idea of basically a certificate of occupancy or a new certificate of compliance upon transfer of ownership. And Valerie and I looked at this, and in fact, I know that I presented to the board two types of local laws for this. But I must say that having looked at it again and having read the other, we both believe, and I'll let Valerie speak for herself, I believe this is one local law that is unenforceable because there is no way that we will know as a building department or a village that someone is contemplating a sale. We will only know after the fact. And I know that Tarrytown has it, I know Peekskill has it, but the difficulty that we see, that I see, is that the way those laws are written, 30 days, 90 days, 60 days before the sale, the seller is to tell the building department, I intend to sell my house. You have to allow me, Mr. Building Inspector, into your house to inspect the house to determine if in fact it's all up to code. And if it is, you get a certificate of compliance. We won't call it a certificate of occupancy. If it's not, you're going to have to get it corrected. And if you don't get it corrected before it's sold, then it becomes the responsibility of the other owner, or the new owner. Now, I should point out, one of the things this board adopted in 2017 was a local law which did say, and we've used this now, is to say that if you are the subsequent owner and there is a violation, it's on you. Even now, even if you've been told it or you don't know it, well, generally through a title search, they will find out if that happens. But the difficulty here is that we would never know about the vast majority of sales. It just a lot of sales now are cash. We'll never know about it. And even if we know and we're asked for a title search, which is done through the building department, we don't know when the sale is going to close, or even if the sale is going to close. We just don't know. And so the difficulty with that is basically being able to do it. The difference between that and the registry is here you're talking about, it could be a single family home where you're saying we want to go in. And what often happens is, we've had this a lot in Indian Village, I put a dormer on my house in 1952. The building permit was literally written in pencil on the back of the application. I didn't get a CO, I have nothing. And as I'll go into in a few minutes with the revision here, there are now provisions which, or would be provisions which will allow the building inspector essentially to say, if it's up to what the code was then, it's okay. But now, under what would be proposed, you'd have a situation where we're not going to give you a certificate of compliance because your house, you didn't get that dormer, or you didn't get the deck done, which is the most, popular violation that you see with this. We just think from that end, it would become very difficult to enforce. And since we already have on the books that if there is a violation, it carries to the new owner. And this board has recently changed a portion of chapter 162 to include maintenance of certain areas. It probably covers what this would cover without having to essentially do something else. Because if I'm owning a single family house, then I figure I have to go to the building department to basically say, oh, by the way, before I can sell the house, you guys got to come in. And, we could put something together. I've done it in the past, as this board knows. We just did not think it was a feasible piece of legislation. It would also be adding a lot more work to the building department because I forget the number of residential sales, but it's well over 100 in the village, if not more. And so they would have to, if everybody did what they were supposed to do, each one of those would have to be inspected and then most likely have to be re-inspected because the odds are someone's going to go into the house and they're going to find something that's wrong. Something. Maybe they didn't get the permit for the bathroom, or they didn't get an electrical over here. Something. So again, if the board does want to pursue that, Valerie and I can do it. We've done it. As I said, I've done it before. My predecessor did it. But the thinking was that it's just would be from an enforcement perspective, particularly very, very difficult to deal with. And frankly, also a tougher sell because you're going to, in many cases, single family property owners saying, now we want to come into your house. We don't want your registry. We don't want to do anything. We just want to come into your home and make sure it's up to code. And this may be a property that has a certificate of occupancy. That's the other point to note. We're not dealing with homes that don't have COs. These are homes that have COs, but maybe they didn't get a CO for their deck. We'll find that out. So it's going to be a lot of work from the building department staff. And I don't mean just the inspector and the code enforcement officers, but people like Lori and Joan, they're going to have to go literally through the records to say, well, did we get a permit for this? And did they get a permit for that? And with some of the homes as old as they are, either we don't even have permit applications, or if we do their paper, we certainly don't have COs in many cases. In fact, pre-52, there are no COs. So we just thought that it was not something right now, but again, we'll defer to the board on that.
Okay. Comments? Not up from you. Manny?
So I'm gonna ask you the technical portions of it. Pre-day letter, CC or CO. What is the difference between any of those three?
Well, the predate is basically that you're essentially saying that at the time it was constructed was okay, which in fact is something that we do now. What we would require a property owner to do is they'd have to go and get an architect, get an engineer to say that deck, when it was built in 2000, conformed with the 2000 code. So no, we wouldn't make them get it up to the current code, but we would have to do something like that. The reason we were saying certificate of compliance is if the property already has a CO, we don't think it would be appropriate to call it another CO or essentially replace the
So
CO.
could you just hold on for 1 second there? So if I have a CO currently right now, why do I need a certificate of compliance then?
The idea was, when we discussed it, the idea would be that if you are selling the property, as you know, particularly Trustee Quezada, you could have a CO, but it might not be the CO for everything that's in your house.
Okay, so that's the difference.
That's the
That's the
difference. So if someone comes in and they say, oh, you've got a CO, but there's no reference to the deck. There's no reference to the basement bathroom. Or you converted the basement into living space, which you never got a permit for. You may have a CO, but you don't have a CO that covers that. That's where this would come in. And basically, put either the current owner or the new owner, if they go through the sale, to do that. The important thing, and I know this came up when we discussed it, a couple of years back, it puts the village should not be in the position of saying, I don't want you to sell the property, because it's not our job, it's not the village's job to do that. And I do think some property owners will think that that's in essence what we'd be doing, is saying you can't sell it. But if they want to sell it with that violation, they can do it. Again, as I said, the current code basically says if you do that, violation is going to carry over. The new owner is going to get that violation as well.
Yeah.
But that's where it would come in. If you have a house and you have a CO for everything that's there, the inspector would come in and say, oh, you got a CO, fine, goodbye, that's it. If not, you would then have to, get a certificate of compliance, whatever we would call it. We haven't really determined what that would be called.
Right, and I know, for example, like I was speaking with Dobbs Ferry and they have it down there and, they said because I asked them, I was like, what happens when, like, if somebody buys the house, right, and moves in and they didn't, and they said, oh, well, usually then we'll let them know and they'll let us in. I'm like, okay, well, that might not work so well in the village of Ossining. And I was, but one of the concerns that we had was, what do you do in those circumstances? Somebody just moves into your community and now all of a sudden, we're issuing more or less violations that, and they don't even realize that they needed that to take place before they even bought the house.
Yeah.
So the rental registry, we felt was just a much more, straight program, and it was a little bit more structured than what we're calling, because you're not even, there was an attorney general's report that suggested not even using the word certificate of occupancy, because that theoretically is tied to like your residential code, right? So it kind of really runs in this like gray area, and we felt the rental registry was a little bit more streamlined and straightforward.
Yeah, but it doesn't solve the problem. If I'm buying a house, a single family home,
Right,
I will never be able to do the register because I'm not renting, I'm just living in it.
right,
So it's a little bit different.
right,
So,
exactly.
I'm okay with what you suggested, with your opinion, and I think was always a concern from a lot of board members in regards to establishing this law, and some of the feedback that I got afterwards, it's the same. I'm okay with not passing this particular law on this case now, but that's just my opinion as well. So, but before that,
Yeah.
what is your opinion, Valerie?
No, I mean, both.
I think they said both of them.
No, he
Right.
was
No,
speaking, he was speaking for
No,
himself.
No, I mean, both Stuart and I, because we started drafting something and the examples out there are very, very minimal, like they're very brief, just saying like, basically you have to do this. And there's really not very little violation, because there's very little, it becomes much more complicated in terms of enforcement, right? And so we were kind of going back and forth, like, well, how do we really deal with this? And we felt, based upon that and based upon some of the other stuff that we read that, and talking with some of these communities, that we just felt that it was the real issue is trying to basically make sure health and safety in terms of especially the rental units, right? And so we felt that the rental registry was the better way to go than this change in ownership certificate. Basically, that's what it's called, more or less.
Okay, Dana? Comments? Okay, so I know why we started the conversation. It started because people buy houses, they go in front of zoning, planning, whatever the heck they go, and they sit there, go, I didn't know. They told me it was a 3, unit and I need more parking, and how am I supposed to know? So we said, well, you make sure the seller takes care of it, because they probably did whatever was done, versus the buyer who didn't know that the deck is now 10 feet bigger than it was supposed to be. And that's a problem, right? What I'm hearing is we don't actually have a solution, because the solution is worse than the problem in some ways. From an enforceability, it's not just the time that it takes. I think those laws were great when it took 6 to 9 months to sell a house. I mean, my house, I think, was on the market for 2 years when I bought it, as was half my neighborhood. Now people sell in a week, in 2 weeks, and it really is a financial burden for somebody who has a buyer They go through the whole thing, they lock in a rate, and we delay it, and they can't even fix the problem, right? It might take them 6 months to fix the problem. It's just not a realistic piece of legislation, like from any point of view. That said, it would be nice to come up with a solution at some point in our lifetime as to people who do stuff and people who buy, and the responsibility of, ignorance is not actually an excuse. Title companies charge thousands and thousands of dollars. And, the answer might be, better talk to your title company who told you everything was fine when it wasn't. But that idea of going in front of zoning and planning and pleading, I think, innocence is really what started a lot of the conversation. So we've got to figure out how, or ignorance, I guess. We have to sort of figure out how to solve for that, but I don't know if that's as big of an issue as some of the other issues we have to deal with. So I'm okay with the recommendation to table, erase, delete, and I think most of the board is.
Put on hold for another couple of years.
Yeah, I mean, but we have other solutions right now that might resolve some of the problems, so let's go with that. Actually, what we'll resolve is if we go back to taking a year to sell a house, then we will know when a house is on the market, because we'll see it. Right now, they turn it in a week, 2 weeks. There's no way, and the rates go up, so you're really financially hindering people. I mean, in like right down to the pocketbook. So I'm okay with where we are. I think everybody said the same thing. Just for the record of why we even started the conversation. What's next?
Thank you, Valerie. I appreciate that.
Thanks, Valerie.
Thanks, Valerie.
Folks, the next is a further revision to chapter 162, which is our housing maintenance code. We've already revised 162 a few weeks ago. We've taken the vacant building registry out, made it now a vacant building and storefront registry with its own standalone chapter. What we've done here is the current Article 6 in Chapter 162 is administration and enforcement. The state has come up with a model law dealing with a code enforcement program, which if you now look throughout the state of New York, virtually every municipality has adopted some form or another. And what is proposed here is to take that, what is now Article 6, out of Chapter 162 and create a separate new chapter 92 of the code, which would be called Building Construction and Fire Prevention Code Administration and Enforcement. It would take what we have now for building permits, certificates of occupancy, operating permits. It includes a brand new section dealing with parking structures, which is something that the state has now mandated in terms of inspections of those structures, and dealing with that. And it talks about when you need operating permits. For example, there's a whole definition in here for mobile food preparation vehicles, or what we call food trucks. And when you have to do that, talks about what the code personnel do. Much of what is in here is already in our code. It's basically just been taken and lifted and moved over. So for example, if you remember, the board recently put in that one of the exceptions where you don't need a building permit deals with resealing of a driveway. That's now, it's just been shifted over. So it's part of this, but it does deal with what is needed. And just so the board is aware, this has been reviewed also by the building inspector. So he went through and made a couple of comments in terms of what needs to be done there. Like the rental registry, it does have a requirement that an agent be designated if you don't have a residence in New York, in Westchester rather. It also requires that if you're an LLC, partnership, whatever, that you have to disclose who your members are so that that information is known. And all that information has to be there. Again, also, post office boxes will not be accepted as addresses. It has to be an actual street address. And this deals with, again, these are applications to the building inspector. There are provisions, stop work orders, which we already have. The other thing that's done here is that the current Chapter 95, which is unsafe buildings, that would be repealed. It would then be carried here. Because part of this is that instead of having a separate standalone chapter for unsafe buildings, part of the code enforcement would be dealing with unsafe buildings. So rather than have to sort of go back and forth in the code, it literally will come right after sections in terms of what the building inspector and code enforcement folks can do. The language itself has basically stayed the same. Some of what is in here comes from some other codes, Town of Monroe, Clarkstown, and a couple of others, upstate as well, in terms of, what has to be done here. As I said, we went into the issue of operating permits. The state now wants you to list specifically when you need an operating permit. Many of these will never apply in the village of Austin. As far as I know, we don't have any fruit and crop ripening type businesses. We don't have too many sugar houses, but the state wants all that in there.
Well, New York State's a big farming.
It is, but so you have that all in there. We have things in here about, inspections, durations of operating permits, when the permits have to be done, how they can be issued, how they get revoked. Also sections on the fire safety and property maintenance inspection, which in fact is just what we were talking about with the rental registry and what those type of inspections have to be, and how they get issued. Again, there's sections here dealing specifically with the search warrants, which we discussed before. So that again, if we need to do an inspection, and we've had this recently with operating permits, and they won't let us in, that's okay. We'll go to court, we'll get a warrant. And then we recently got, I think we got 12 warrants, which were basically dealt with, no operating permits. And frankly, once the warrants were issued, I think we only had to actually serve the warrants on 2 or 3 places. Basically, after that, they let us into the places to do what needed to be done. As I said, one of the big changes deals with parking garages. The state has been very clear that they want to have, when I say parking garages, I should be clear, parking structures is what the definition is. They want something that's called a condition assessment report. Depending on when it was constructed, will determine when you have to have it done. But generally, once you have it done, you've got to have an assessment every year. And it's got to be by their engineer, and they submit it to the building department. This will tie into something we'll be discussing later in exec, dealing with structural engineers and things like that. But it's important because we will be seeing a number of parking structures in the village, not referring to multimodal, but also referring to other locations, which will require all these types of inspections. We actually have a few parking structures in the village right now that would be covered by this.
Like where?
Harbor Square is one, Scarborough Manor has one.
Oh, actually, a lot of the buildings do. What am I talking about?
So there's,
Things underneath the building, but I found them.
basically, the way they define the parking garage, it's any building or structure in which any part of any structural level is used for parking or storage of motor vehicles, excluding the following: buildings in which the only level for parking is on grade. So if you're below grade or above grade, that's a parking structure. An attached or accessory structure providing parking for a detached 1 or 2 family house is excluded, or a townhouse unit with attached
Oh, there you
parking.
go.
So basically, anything else other than that is considered a parking structure and has to have a condition assessment.
Okay, so I'm sorry. So all the townhouses that in the
Would not
townhouses.
be- would be
Okay.
excluded.
All right, wait, hold on. You done?
Uh,
And then we'll,
Two small things. The code now, because the state is very big on climate change and climate work, will require the building inspector to determine the climatic and geographic design criteria for buildings and structures that are constructed in the area. It's not as difficult as it sounds. It's actually a chart
I was gonna
that will
say.
tell the building inspector what those numbers are. All he has to do is go to the code and the numbers are there. So it's not like.
okay,
When it says determine, that's what the state code says, but it's not as much like that. If I can just look through here, we do have here, unlike the rental register, we have I think a more robust, what we call an entity disclosure law, where basically owners have to disclose basically who you are, essentially, who's the owner. Not just necessarily LLCs, but it sort of goes into it in greater detail. Does not apply if you're just putting in a swimming pool, does not apply in a single family house, does not apply to a 2-family house, does not apply to outdoor decks. But for certain types of construction, you're going to have to give certain information as to who it is who's basically doing the work, or not doing the work, but who's making the application. So that's basically what would become the new chapter 92, pulling out certain articles out of chapter 162. It's the continuing evolution of chapter 162, I guess, is the best way to say.
Okay. Go ahead.
Thank you. And I'm okay with that. And hopefully, when 2025 comes in and the state goes to IBC again, you won't have to go back to all this other craziness.
One would hope.
Yeah, very much. So I do have a quick question though,
Sure.
in regards to the garages. And probably you remember this better than I do, Stuart. A few months ago, and I think it was probably sometime last year, we actually did pass a local law, or we put something in regards to garages and parking garages on the ground where we were asking to do the reporting. You don't have to answer me now, just go back and I
Okay,
have to
I'll
go back
look.
to some of the stuff, but I think we established, and that was, I guess now my question is, that's not just on the ground, to get the
Correct.
reported, it's pretty much anything but the exceptions that you just read. So just double check that for me.
I will.
Because if anything, we'd be limiting ourselves in some of the stuff that we can do. Either we eliminated the law or we attach or amend the law to reflect what New York State is asking for us to do.
I
That's
will,
all.
I will
Yeah.
look it up because what we can do, because we've done it certain parts here, is the state is the model code. In fact, as the state says, you don't just follow the model code. You would be surprised at the number of municipalities who literally took the model code, did it, but with parentheses and with blanks. That's how they adopted it. They didn't even read it.
Yeah.
So we can, there's no question that with that, we can just
Yeah.
change the parking to basically make it more inclusive.
Correct.
So that's
Yeah.
not a problem. I will go back and check that.
And I thought for some reason in regards to the climatic table itself, which is I think we have that in our website already, because I think Joe is doing that already. Because him and I have already have a conversations about.
I will say this, some of what is in here, particularly the parking garages, is already being done because we've actually written certain violations where we do not get the timely assessment
Yeah.
reports. So it may well be that that's done. This way, it just puts it into the code because otherwise it wouldn't be there.
Yeah, because I seen that, but yeah, thank you.
else? Bob? Okay, Dana? Good. I just have one question. Single homes or two-family home, actual garages. Where are we with, like, how does that fit into inspections? I only say this as a resident who, like everybody else, drives through, and there are garages where I guess there are cars inside. I don't know what's inside that are, the houses are not in bad shape, but these garages, doors off, plywood instead of a door. Who's inspecting this garage? I mean, they're amazingly unsafe. Like, how are they part of anything?
I can tell you this, I know, again, by reading orders to remedy, that we often have violations written for problems with garages, be it that the door is not, because any requirements for exterior property or even interior, if they can get in, that applies to the garage as well. So for example, if there's siding coming off, if the door is coming off, if the roof is.
And can you go and look at, well, the garages you can see from the outside, because when I drive by, I see it.
Right.
Can you just do an inspection just on a garage, or you have to do the house?
No, if the code enforcement officer were to see a violation in the garage, they can just do the garage. They don't have
Okay,
to get in there. So that absolutely they can do.
so that's already in our code, that's already established.
It's considered basically it would be an exterior,
Well, that's-
exterior terms of
Okay.
property.
Yeah, that's falls under actually not just local, but it falls under New York
State
State
code as well.
property. maintenance.
Well, I'm just questioning because I see some garages, I mean, you could see them just driving down 133, you could see it like from anywhere. Doors are just off the hinges. I mean, I'm not sure that garages have to be used for cars. I mean, I guess they're allowed to be used for storage. I only get upset when I hear from people that there's no parking, and then I look and there's like a 2-car garage being used for storage, not for cars. But that's a different issue altogether.
I can just tell you, Mayor, that if it's a structure, be it a garage or something else, and I know because we recently wrote, I think, either an OTR, order to remedy, or an appearance ticket for a property where literally the roof of the garage had collapsed. I mean.
Oh, I'm
and they could
sure.
See it from the street.
Yeah,
It was written up and had nothing to do with the main house. It was just the garage. And
Yeah.
then, so the answer is yes, they do get it.
Okay.
Our code and state code both deal with that.
okay, that's fine, that's good. Excellent. I think that's it for the question period, and it seems like we're moving forward on it. What else we got?
we can adjourn now for executive session.
Okay, we're gonna have a long executive session, so, I guess there's a motion, to exec session for legal and personnel, actually, I
It's
think,
for
or just
it's for
legal
matters of collective bargaining.
and personnel. Okay.
So move.
All in favor?
Aye.
All right, ladies and gentlemen, it's 9:10 and, we will see you next week, legislative session. Oh, I'm sorry. Sorry. In 2 weeks for legislative session. And we are adjourned at 9:12.